Hello everyone. Welcome to Sessions. And we're going to be talking about living trust today. And we have a very special guest here, Brian Tom, who's a friend and also my personal trust attorney. And there's a lot to cover here. The importance of having a trust, how it protects your family, your estate, your legacy, your wishes. And I know a lot of you are a little crushed for time, so we're just gonna let Brian have at it.
Thank you, Gene. Thank you, everyone. And it's our pleasure to be here. It's thank you for spending your valuable lunchtime to join us. My name is Brian Ton, and I'm an estate planning attorney. I've been doing this for probably 25 years now. Today I'm going to be talking about the benefits of holding the property in the trust. And then, Gene, maybe you can let people know how they can ask questions. We could either do during or you can handle that. And then just let me know if there's any question for people. So I'll be happy. And I think that either during or maybe after. Just a little bit about me. I've been focusing on estate planning and corporate law. It's actually a little bit more than 20 years. But my background, I had a law degree from State University of New York and get an MBA from Wharton Business School and a CPA in New York State. So that's why my practice around estate planning and business transaction. I speak Vietnamese as well. But what we do is we do a wide range of trusts, anywhere from a simple revocable family trust to complex irrevocable trusts. We also, in addition to estate planning, which that was our focus, but we also do probate for people who pass away who didn't have any trusts. And then we do trust administration for people who have a trust that passed away to help their family distribute the assets. And our goal is to build family harmony and building legacy. And by law, I need to kind of put a disclaimer that we're not giving you any legal advice in this presentation. We just for informational purposes, understanding, and even doing questions and answers, basically it's designed for you to understand better, to share with you my knowledge for all these 20-some years. And there's no, attorney-client privilege or attorney-client relationship in this case. I'm fortunate to be able to engage with you. If you are engaged by you, then we enter into a relationship, attorney-client, which I hope to do. But for today, I just want to be as informational, as a resource for you as much as possible. A lot of people ask me, what is a trust and what is estate planning? And, estate planning, the word estate is very, kind of misleading because you don't need to have a huge asset in order to call the word estate. Estate just means your asset upon your passing. You don't need to have a lot of assets in order to have a legacy, because for us, we really care more about the legacy, the overall impact that you leave with your children, with your loved ones, rather than just the amount of your wealth. It's your blood, sweat, and tears that you save over these years. And so, for us, money really does not define legacy. Legacy is everything that you do in addition to the asset that you leave with your children or your loved ones. And our mission is to help you grow your legacy. And the idea of our planning is to help you how to get the biggest bang for your bucks, basically. And the trust, for purposes of those of you who don't have a trust yet, it is just a legal entity that really holds title to your assets. And it's usually for revocable trust, it's totally changeable, amendable while you're alive. Upon your passing, nobody else can change it except you. So at that point, then nobody else can change because you're no longer around. Another aspect that what we focus on is also doing incapacity, because with the advance in medical field, we can live a little bit longer, but a lot of time, our mind is not as clear. So incapacity planning is actually part of estate planning. And so we want to make sure that when you incapacitated or your capacity is diminished, there will be somebody, there's a structure, there are people that will take care for you and take care for your assets, and it allows, so that we preserve it. And again, I mentioned again, our goal is to to maintain peace of mind, family harmony. And it is a very quick and inexpensive way to transfer wealth at death. And without the trust, a basic trust, without proper planning, it will give you a lot of headaches, not only you, but also your children. So, and then we also want to make sure that to protect the beneficiary from others and from themselves. And that's kind of more asset protection. And then just a little bit more about the probate court, why it's important, because it is, if the law here in United States, in particular California, that if you pass away, if your asset level right now it's about $200,000, then you will be subject to probate court unless you have a trust. So, and if you only asset is the primary residence, and now the exemption is up to $750,000. But keep in mind that this is the value; it's not the equity. Even though if you have a lot of debt, for the probate court purposes, the test is the value of the house. So a lot of time the value keeps growing up, and so even though if you have a little bit of equity, that doesn't matter. You still may be subject to probate. And the cost is very expensive, and that's why it could be, for an asset for a state, up to $5 million could be $65,000. So, it's much better to do a simple trust to avoid the probate. And the timing is also, it requires a lot of time. Usually takes about 9 months minimum most of the time, and, a year's average. So, and then, but if you have assets that are in the trust, either if you have a trust or you don't have a trust, the properties could be either real properties or financial assets or businesses. These, you do not want them to be tied up in court because they will have consequences. If you have a business, your business cannot run smoothly, particularly if you're not there, but also if you're held up in court. And real property, if you can't refinance during that time, and sometimes you have to notify the banks right away upon your passing. So there may be a risk of maybe that you have to refinance as soon as possible, and particularly if you have businesses. And then retirement accounts, make sure that you have beneficiary designated. If you don't, that will be subject to probate as well. So, the goal is to shield your asset from being lost or seized. If you're in probate, you have to satisfy all the existing creditors before you can pass, before even you can close probate. So so that's unfortunate because you have to satisfy every single creditors, even though some of the creditors are very unreasonable. But you can't really delay the settlement. You have to do that before you can close probate and distribute to the ultimate beneficiaries. Then even if you have a trust that you leave it outside, those assets outside could be subject to probate if they over the threshold amount, $200,000. And also the trust will also help, while you're in probate, it's open up for dispute because anybody can go to court and object to the trust or to anything that happens. So that would be held up. Those are the reasons why the probate usually tend to be longer. So, and in a trust, let me talk a little bit about the trust structure. When the adult, usually we would designate the adult child to become the trustee. If you are diminishing in your capacity, we can, it is possible to have an adult child to be co-trustee with you. Or if you're concerned that, say, if you're a married couple, you're concerned that if one of you passes away, you may need additional help. So that's where we can do the trustee. But in a typical structure of the trust, you are the creators of the trust. We call either settlers or grantors, and then you also the trustees, and you also beneficiaries when you're alive. Upon your incapacitated or passing, then you will need to designate successor trustees, and that is usually a complex situation too, because who you appoint as a trustee can make a huge impact down the road. The trust structure is usually there's a way to protect your young children. If you're young children or young grandchildren, we can set up in such a way that the money is not distributed right away to them, but basically the money can be used for them while they are minors for purpose like health, education, maintenance, support, and then you can leave it up to kind of decide certain age where they become a little bit older, where you can safely distribute the properties to them. And then I know a lot of people are concerned about taxes. So again, I'm not a tax expert, but I just want to give you a little bit overview. The taxes that impact your estate planning would be the first one, income tax. You have ordinary income and capital gain, and these have impact on how you pass your estate. And then property tax. Property tax is based on the assessed value of the property, and there are a lot of new laws regarding that. And then the estate and gift tax. So that is for asset that above certain level. Right now it's about 14 million per person, but that can fluctuate. And then but the state tax bracket rate is extremely high, 40%. Keep in mind that a lot of people just say about tax in general, but there are three distinct different taxes that you have to worry about. Even if your asset is not as high as 14 million, you still will be subject to income tax and property taxes. So these are the two things that for the lack of time, we're not going to go in detail, but just to know that there are several taxes in at play here. And then so I'm not going to talk too much about estate and gift tax, but estate and gift are usually they go together. So if you gift the $14 million apply whether or not you alive or you pass away. So if you're alive, you give away, that's called gift. And everything added up to the $14 million. So you can choose to give earlier, but that will be included in your lifetime exemption, which is $14 million. And anything above that would be subject to 40%. The property taxes, I'm going to touch upon a little bit the Prop 19, which is the new taxes affect new laws that really means that the limit right now is only if your residence, where it used to be a parent-child exemption from parents passing on properties to children, but right now you limit it only to one property, and that property has to be resided by both you till your passing and your children that have to move in within a year. So if you have any other property, particularly rental properties, that will be subject to reassessment. The other upside, I guess the other benefit of the new law is that it allows you to downsize or upsize while you're still alive without really, and can still maintain the similar tax base. So when you buy a new house, you can actually transfer that tax base. So that's, and the new law expands that, allow you to go up rather than just to go down in terms of the house. But the downside is the severely limits the number of houses, or severely limit the amount, and exclusion also limited to just $1 million, even for your residence. And these are some consequences for not putting property in the trust. If you don't put property in the trust, if you pass away subject to probate, you can't really put your property, you can't really sign closing documents. And we have a lot of people who happen to pass away while they are in the middle of escrow. And if that's the case, immediately you'll be subject to probate. And you cannot close. So that one of the risks that you try to avoid by having a trust before you sign the listing agreement and before you list your house, because that would ensure that the sale will go smoothly, because then whoever's successor trustee can complete the transaction without having to have the court involved. And again, the probate takes 9 months to a year. So, and then sometime the court has to approve. It doesn't mean that you have to wait until probate is done, but there will be severely restrict the flow. You can't really, the trustee cannot singly decide where to sell. Usually we have to get a kind of consent from all the beneficiaries before you can sell, because no longer you no longer around. So because normally you would be the only one who make decision, but now the decision is shared among the beneficiaries do have an impact on it. So again, and estate planning is just a lifelong process. It's something that's not just one time. Although having a trust will last a long time, you don't really need to change all the time. only if you wanted to, only if your lifestyle changes or situation changes. But so I would recommend to update regularly, and if any changes, you do that right away. And we have a lot of cases where you buy or sell real estate, and you buy new real estate without putting in a trust, so that can put the house subject to probate. So you can always update. And for those of you who already have a trust that was done a long time ago, that should the tax law changed in 2012. So the structure right now is much more flexible, much more tax friendly. So I would recommend to take a look at it and see if there's a ways that you can update the trust and make it more flexible, more tax efficient. And particularly the AAB trust for married couple is a prime example of that. And then trust administration, I do talk a little bit about it, and it may not be on your at the top of your mind, but trust administration is something. What if you have a trust and you pass away? What happens then? So that's something that we also do a lot of trust administration for the past long time since I've been practicing. So I've seen how families interact, how things happen after post-death. And so that's why doing trust administration gives me valuable information, experiences, and how to help you with your estate plan, because then you know what to avoid. A lot of time it's very, it's not that obvious, but things that happen when you're not around, when you're no longer the anchor of the family. So there may be things that would happen then that does not happen now, that's not so apparent now. It's hard to think about it, but we will be able to help you. So in some set up an estate plan. You already have one, then make sure you update it. It's much more estate planning, much more than financial planning. It's a legacy planning. So with that, thank you very much for your group. Let us know if you have any further questions. And again, we do estate planning, trust administration, probate, and business, and conservatorship as well. So thank you for your attention, and I hope that we share with you a little bit of about the estate planning process, about the implication, about the risks, about the solutions, how to avoid them. So we are open up the floor if anybody who wants to have questions. And Jean, I'll pass it on back to you. And again, thank you for your attention. Thank you for your participation. And thank you, Jean, for the opportunity.
Of course. Thanks so much, Brian. Yeah, having a trust, well, it's just some really peace of mind. Just to give a little background, we didn't have a trust, my wife and I, for years. And in 2017, we had an event. She had breast cancer. We have a 3-year-old. And even though I was healthy, it just all kind of triggered. So it's like, what's going to happen to our daughter, if I were to get sick too? And it's not only who's going to take care of her, but who do we not want to take care of her? I remember having that conversation with you. And also, what would happen if 18, she just has all this money and has a house and everything? That could be very problematic. So my wife was really big on, well, she needs to be at least 25 when she has a fully developed prefrontal cortex. But anyway, I have a couple of questions here. There's something they have now. It's the transfer of property deed or something you can write. I guess people call that a poor man's trust. What can you explain a little more on that, how that can be helpful or why it's not enough?
Yes, this type of deed, it's a transfer on death deed.
Okay.
These are so you actually designate, you write on the deed that upon my passing, then these people will go automatically to these people. So the reason it bypasses probate, because it, basically upon your death, immediately the title transfers to the whoever you designate as a beneficiary. So yes, it does avoid probate, it does avoid having a trust. But the downside of this is that having a trust or having probate, it actually clears the title. What if the person who owned, like you are the previous owner who had a lot of debt? The biggest problem is refinancing. You may not be able to refinance for several years because no banks will be willing to have the transaction. And it's hard if you want to sell the property. Escrow, if I'm a buyer, I do not want to buy a property that the title is not clean, because there are potential liabilities attached to it that has not been cleared. Again, probate is the process of clearing. Trust is the way to notify everybody of the previous creditors. So by having a trust, the creditors cannot go after you die because go after your beneficiaries because
Okay.
they properly notify. So probate and trust are the two ways to notify previous creditors. The TOD, transfer on death deeds, do not have that. So usually, I think that in terms of title insurance, they may not be able to give you a title insurance until a few years after you pass. So those are the limits that a lot of people don't realize that now, unless that's the only property that you have,
Mm.
and that you don't plan to, you own it right, your children would never need to refinance it. You don't need to sell it right away. So those
Okay.
are cases that you can do. So it's a great question, Gene.
Okay. And I guess follow up on that as well, that can't apply to anything else. So someone has, a few $100,000 you know, in some securities or something like that. Well, they would name a beneficiary, but that could still open it up for questions from other heirs. Could that?
Yeah, although that is not less because when you the real properties, you have to go through escrow, you have to get title insurance, you
Hmm.
get refinance. So you have the third parties who really, their business is make sure that, the title is clean. So for financial property, usually it's not as public, whereas the
Okay.
title to real property is very public. And because of that, refinancing and financing and transactions, buy sales will be very, very exposed. Whereas the other one, is a little bit more, I guess, discreet
Okay.
or
Yeah.
financial.
That's
Yeah.
really good to know. Another question along with that, not along with that, but there's other, you mentioned like power of attorney, so that continues with the trust, but if you have power of attorney and die without a trust, it expires, correct?
Yes, that's
Yeah.
why in a trust package, we do three documents. We prepare
Okay.
three documents. The trust usually covers assets that are in the trust for incapacity and upon death. For asset that unfortunately, if you don't put in the trust, whether by intention, whether by, if you forgot to put it,
Ownership.
or by law, certain like real retirement properties, retirement accounts, you cannot put in the trust. So those are categories where you are outside the trust, and that's why we need, in addition to the trust, we need two additional documents. One is power of attorney.
Mm-hmm.
Um, that's for while you're still alive but become incapacitated. And then upon your death, as Jean pointed out, the power of attorney is no longer effective. So the next document is called the will. So
Yeah.
through the will, again, you will also designate a somebody, usually we call personal representative or executor of the will. That person will be able to can be in your shoes to make decisions. So, for
Right.
example, if you become incapacitated, like Social Security, if you release Social Security or retirement accounts in particular, if you become incapacitated, the person who has the power of attorney can really be on your behalf and deal with the administrators of these retirement accounts. Upon your
Mhm.
passing, if you do not have beneficiary designated, then the person under the will have the ability to communicate with the administrator. But keep in mind that if retirement accounts that have no beneficiary designated will be subject to probate because it
Yeah.
reverts back to your estate and you have no trust because by that time the trust is not in the trust yet, so you have
Yes.
to do that. So yes, so by the operation of three different documents, the power of attorney and the will, then that you have a complete protection
Yeah.
against passing and incapacity.
Yes. And another one I remember we added in ours is the medical directive as well. Um, so important as well.
Yes, I think that's another part of the trust that we do as well is medical power of attorney for medical. This is extremely important because a lot of times, now even though it's not part of estate planning, but it's not financial, but that affects your well-being, affect your
Of
family,
course.
affect your legacy. So, and again, if you do not have a proper power of attorney for healthcare or advanced healthcare directive, that would create a problem, even for the day that you get admitted to ER or in the hospital,
No.
because it's not automatic that if you're a child or if you're a spouse, that you can make decision for that, somebody can make a decision for you. So there's so many cases where the fight between, the new spouse and the children from prior marriages, and so that
Mhm.
usually this will avoid that fight. Why in the hospital?
Yeah. Well, Brian, thank you again so much. You know, as my clients, when I sell them houses and everything, say establishing a trust, make that such a huge priority. People pass away, and I've seen it on both sides where there's fighting, there's bickering, and there's always going to be some type of animosity quite often. You don't know what happens until someone passes away and the gloves come off. And it's such an unnecessary and expensive thing to put your heirs through that. So, of course, I'm partial to Brian because he's helped our family and so many of my clients. But just find someone, get the help, and protect your family, your assets, your legacy. And thank you again. All right.
Yeah. Okay, thank you, Gene. Thank you, Lisa,
Okay.
and
Thank
All
you
and
so
right.
thank
much,
you,
Brian.
every one of you. So
Okay.
thank you for your time. All right.